On April 7, a three-member panel of the appeal court led by Justice Rita Pemu granted the People's Democratic Party (PDP) permission to file a suit as an interested party against the March 18 judgment of the Federal High Court, Umuahia, Abia State. The Abia Court, presided over by Justice Evelyn Anyadike, had ordered the Attorney General of the Federation to delete Section 84, subsection 12 of the Electoral Act. Justice Anyadike delivered the judgment in a suit filed by a lawyer and member of Action Alliance, Nduka Edede. Dissatisfied with the decision ordering the deletion of the section, the PDP approached the Court of Appeal, which subsequently granted an accelerated hearing of the suit. The Court of Appeal has now agreed with the PDP and held that the Abia Court lacked the jurisdiction to hear the suit, as the plaintiff lacked the legal standing to have filed the case. The court subsequently set aside the judgment of the Abia Court, and the implication of this is that to the mind of the Court of Appeal, Section 84, subsection 12 will not be deleted, as it remains the law until it is set aside by the Supreme Court. Even though the live issue was on jurisdiction, the appeal court went a step further to determine the case on its merit. And this is where it gets interesting and perhaps confusing. The appeal court said if it were to decide the case on its merit, Section 84, subsection 12 would be unconstitutional because it is in conflict with Section 42, subsection 1A of the Constitution, which would deny the political appointees their right to participate in the elections. The implication of this is that the Court of Appeal believes that if the suit had been properly filed by a person who had the requisite locus, Section 84, subsection 12 would amount to a bad law on grounds of discrimination. Some people argue that this decision on the merit is an academic exercise. Others fault the reasoning of the court, arguing that Section 42, subsection 1A is not absolute, and the point especially to the proviso, or exceptions if you like, in subsection 3. Make of that what you will, but what is clear for now is that the directive of the President for ministers with political ambitions to resign is in line with the intent of the lawmakers, which seeks to create a level playing field for all candidates at the polls. Shola Shoyeli, Channels Television News.
To further discuss this, we're being joined by Senior Advocate of Nigeria, Olukayode Enito. A pleasure having you with us on the news at 10.
Nice having me. Thank you.
Now, where do those who have been affected by the various provisions stand today in the eyes of the law?
Well, you see, the decision of the Court of Appeal, it's clear, it's simple. It says, one, the individual who went to court lacked standing. As such, the suit was struck out. Now, as they are meant to do, it was an originating summons. When an originating summons is brought, all the facts have been argued. The legal arguments have also been properly stated. The court is enjoined. Even when it says, oh, the lower court lacks jurisdiction, it will still give a decision on the merit to save time, which is what they did here. Now, this judgment, of course, there's still a lap to run. The Supreme Court is there.
Yes.
I see both sides appealing. The appellant would go further to say they were wrong in what they have said on the merits. What have they said? That Section 84.12 conflicts with Section 142. Now, on what basis did they arrive at that conclusion? The second respondent, who is the Attorney General of the Federation, who was a defendant in the lower court, filed a respondent notice. Now, a respondent notice is provided for under Order 9 of the Court of Appeal rules. That order specifically is made for the person who won in the lower court. Okay. You won in the lower court, the person who lost has now appealed. You are asking the Court of Appeal to affirm the lower court's judgment, but not on the grounds the court used. So you're giving the Court of Appeal another reason to say, look, the judgment was right, but it was on these grounds, not on the grounds that they found. In this instance, it was the person who lost in the lower court who is now saying, oh, you know, affirm that judgment on this ground. I'm not aware of how that was arrived at.
But would it be correct to say that the law provides separately for civil servants, public servants, and appointed political office holders in this case?
Yes. The political office holders are clearly not caught by, they are not public servants. That's very clear. The court clearly stated that. The Court of Appeal agreed that they are not public servants, they are not civil servants. However, the court went ahead to say that they are a community of persons who have been discriminated against by that law. Are they a community? They are not. Each of them none of them have been discriminated against, in my view. All they needed to do is resign. No one says you cannot contest. Okay. All the Section 84(12) is saying is if you want to contest, you're free. These are the conditions. You cannot be holding political office and at the same time be a delegate voting or seeking votes.
But quickly now, since there's still room, a possibility that they will move to the Supreme Court,
yes,
you know, doesn't that leave an uncertainty?
No, right now, the decision is that the person who went to court lacks standing. Okay. What is the judgment as of today? It is that Section 84(12) is valid because there is actually no decision on it. Remember, the Court of Appeal has struck out the suit, so there is no suit. The decision on, in case we are wrong and the court has judgment, that is not going to be what will be held until the Supreme Court says, oh yes, we agree, or we disagree.
Senior Advocate of Nigeria, Olukayode Enitan, a pleasure sharing your thoughts with us.
Thank you, Melinda.
On the news at 10.